You'll hear a bit more about my background and Farnaz's background in a moment, but both of us were in-house counsel at universities prior to coming to McGuire-Woods, and so we really know and appreciate how valuable your time is. And we hope that today's session will be a really practical, informative webinar where you feel free to have engagement with us and ask questions. And we're recording today's webinar, and you'll get a copy of it after the webinar ends. But when you ask us questions, please know that your identity will not be revealed to the group. It's only Farnaz and I that can see it. And if you ask a question that we don't get a chance to answer, we will follow up with you after the webinar. And likewise, if you don't feel comfortable asking your question today, or you want to follow up with any of us afterwards, please reach out anytime. We're really hoping that we can do this on a quarterly basis and build a great community of people that work with you to support the incredible work that you're doing for your institutions. So by way of background, my name is Sarah Wake. I am a partner in McGuire-Woods' Chicago office. I actually started my career in the Labor and Employment Group at McGuire-Woods in 2007 as an associate in the employment group. And I left, and from 2013 to 2017, oversaw discrimination, harassment, and sexual misconduct, including serving as the Title IX coordinator, and also oversaw affirmative action and disability accommodations at 2 universities. And at one of those universities, I was also involved in research, tech transfer, and commercialization efforts. But I spent the last 5 years until December of 2021 as Associate General Counsel and Associate Vice President for Equity at a major research institution with Division I athletics programs. And at that university, I had 3 main areas of focus, which were student life and student conduct, athletics, and diversity, equity, and inclusion. So I'm very happy to see you all today, to see so many familiar faces and new friends. And I'm also very grateful to be joined by my terrific colleague, Farnaz Thompson, who's a partner in our DC office. So Farnaz, do you want to introduce yourself?
Yes, thank you, Sarah. My name is Farnaz Thompson, and I'm a partner in the DC office, also in the Labor and Employment Law Group. I joined McGuire-Woods almost a year ago, and Sarah and I have been leading our efforts on the education team front, and we are delighted to talk to you today about various topics. My background is that I was in-house counsel at a public research institution, a very large one in Virginia, and I handled student conduct as well as employment law issues. And after the in-house position, I had an opportunity to serve as the Deputy General Counsel at the U.S. Department of Education's Office of General Counsel, where I worked on a number of regulations, and my primary clients were the Office for Civil Rights, the Office of Post-Secondary Education, and the Federal Student Aid Office. And we will be discussing some of the regulations that concern your institutions today. And so with that, welcome. We would love to talk to you first about admissions policies and what you might be anticipating in 2022 when it comes to admissions. So back to you, Sarah.
Thanks, Farnaz. So as Farnaz said, we're going to start today talking about admissions. Our goal in each of these sections is to give a very high-level overview of each of the topics and then talk about what are some practical things that you can be doing right now. We recognize that we could do a full webinar on any of these topics standing alone. So this is really just meant to be kind of flagging things for you that might be of interest and giving you some practical next steps. So first, with admissions, you know, as we all know, the United States Supreme Court has agreed to hear challenges regarding the use of race in admissions at both a private and a public institution. And the court will most likely hear those cases next term, which, as you all know, starts in October. So the current framework, of course, is that colleges and universities can consider race in admissions on a limited basis if, when doing so, the considerations are narrowly tailored to serve a compelling interest, which includes the educational benefits of having a diverse student body. This is known as the strict scrutiny standard, and I would highly recommend to those of you that haven't already that you read the district court's opinion in the Harvard admissions case, which I thought did a really incredible job of giving some color to those terms, narrowly tailored and a compelling interest. So a lot of times, you know, we speak about these terms without really thinking about what they mean. And I know that they can be confusing to admissions folks. And that Harvard opinion really does a terrific job of explaining what some of those things mean. So I would I would take a look at that. But in my opinion, the current framework about using race in admissions hinges on three things. So you want to engage in an individual review of applications, obviously. You don't want to use quotas, either internally or externally. And you want to make sure that your admissions are really continually evaluating whether there are race-neutral options available in terms of admissions practices. And, you know, I'll talk about in a minute what that looks like, but we'll see what the court does next term. But I think in the meantime, it's really important for you to work at a handle on what they're doing so that we can know what we're doing in the event that we have to pivot, and also in the event that we just want to make sure that we're being compliant with current best practices and the current standards. But I do think it would serve you very well to engage in an in-depth way with your admissions team and see what they're doing currently. Universities are very siloed. I found in my experience that admissions are even further siloed, and you have a team of really outstanding people who are experts in their field who know what they're doing. But I do think it will serve you in the long run to kind of have your legal office engaged in a very concrete way with your admissions practices. Another interesting thing that's happening in college admissions right now, and we'll talk about how these things kind of all come together, is an antitrust class action that's currently pending. Literally, I can see it out my window here in the Northern District of Illinois. And it's called the Henry case. And it's poised to be a class action against what was initially 16, but I think now 17 elite institutions. And the plaintiffs in the Henry case allege that the defendant universities violated the antitrust laws by participating in this 568 presidents group, which the plaintiffs allege is a price fixing agreement among these universities related to financial aid. And the plaintiffs are claiming that this 568 exemption, which is an antitrust exemption in the Higher Education Act that allows institutions of higher education to agree to use common principles and mechanisms when it comes to determining financial aid, as long as the universities are granting admissions on a need-blind basis. And the plaintiff's theory of the case is quite interesting. And they're alleging that a subset of these 17 schools aren't engaging in need-blind admissions in three ways. And one of the ways in which they allege that some of the universities are not engaging in need-blind admissions is that they're giving preferential treatment to the children of legacy admits or donors. And so they're saying, you know, you're not truly need-blind because when you're admitting Sarah, you're considering the fact that her parents gave significant donations to the institution. That's purely a hypothetical that did not apply to me, and I'm saying. And I think that this is really interesting for three reasons. This case is notable and worth watching for three reasons. The first is that one of the plaintiff's attorneys in this case was the lead prosecutor in Operation Varsity Blues. And he's a very good lawyer who has an incredible knowledge and sense of admissions. And so I think watching how this case develops and watching the arguments that are made by the plaintiffs will be really interesting in terms of, you know, seeing the case from that lens. The second way that I think this case is really interesting is it shows that antitrust is just exploding in the context of higher education, which is a relatively new phenomenon. And we're seeing it a lot in the athletics context, but this case, I think, shows that it's seeping into other avenues as well, and that it's really something for you to be aware of and keep your eye on. And the third way that I think this case is interesting is it shows that admissions, much like athletics, is really under fire from all different angles. You know, we talked about the use of race in admissions being under fire. Now we're talking about the ways that schools can kind of collaborate to talk about admissions and financial aid being under fire. And another way that admissions are under fire right now is in the context of legacy admissions. And so, you know, the legacy admissions criticism and scrutiny really, really picked up a lot since Operation Varsity Blues, in my opinion. And what's happening now in admissions is Colorado, I think, was the first state to pass a law that bans public schools from considering legacy admissions in their admissions process. Right now, Connecticut and New York are considering similar laws that would apply to public and private institutions, which, as you can imagine, some of the private institutions are quite concerned about and not in favor of. And also in California, they don't ban legacy admissions, but they do require institutions that receive state financial aid to disclose how many applicants were accepted with consideration of legacy admission status. I think the most interesting thing to watch, which I do not think will probably become a reality, is that Congress is also considering a bill that would deny federal financial aid to colleges who use legacy admissions or give any type of preferential treatment to the children of donors. So that one is certainly something that will be interesting to track. Like I said, I'm not sure that it will get legs, but certainly shows that this issue of legacy admissions is under scrutiny. Some schools, including Johns Hopkins and Amherst College, have voluntarily decided that they aren't going to use legacy admissions anymore. And I think it'll be really interesting to see what schools make that decision on their own and how this issue of legacy admissions kind of tracks with the challenges that we're seeing, to the use of race in admissions. I'm going to transition it in just a minute for Farnaz to talk about things that you might want to be considering in terms of legacy admissions and a disparate impact analysis that could come into play. But before I do that, I promised to give you some really in the admission space right now. And here's what I would be doing. I strongly recommend that you do some type of an audit on your admissions practices, either with your general counsel's office or in partnership with someone that you retain to do a privileged audit. And I think that you should, at the very least, have somebody look at your internal and external documents related to admissions and do a roundtable session with your admissions teams to talk about how do they understand these terms narrowly tailored to meet a compelling interest. So how are we narrowly tailoring our efforts? What would your admissions people say if they had to testify at a deposition or in a trial about their practices? Again, I think that this Harvard case is a really good point of reference. Their head of admissions did a terrific job at that trial testifying about their practices. And I think that you also want to hear how your admissions teams are continually evaluating whether there are race-neutral alternatives within their admissions practices. So I think you just want to really understand what they're doing. And I'll share a story about an audit that I recently did with a school that was full of these incredible, professionals that are leaders in their fields. And we're doing this roundtable session where we were going through all the documents, and they showed me some of the internal documents that they used. And they said, for example, 33% of our class African-American, 52% of our class women. And they called the document goals for admissions. And I said, can you help me to understand this a little bit? And they said, well, we found out that we can't use quotas, so we just changed the word quotas to goals. And I said, have you changed your practices at all? And they said, no. And so that's just an example of a really well-intentioned group of people trying to do the right thing, trying to enhance diversity and inclusion at their institutions, which are such incredibly important goals for so many of you, but really not quite understanding the legal framework that applies. So that's why I think an admissions audit and forming these relationships with your admissions teams are so important as we continue to see admissions practices be challenged and evolved. So with that, Farnaz, do you want to talk a bit about the disparate impact context that you see could come into play with the Department of Ed?
Yes, I'd be delighted to. And before we do that, there are actually some courts that have considered whether legacy admissions are lawful. And they have concluded that legacy admissions don't violate the Equal Protection Clause or Due Process Clause. And so I'd like to go over those cases briefly. And Sarah is quite humble, but she was quoted in Law 360 when the Supreme Court of the United States granted cert in the cases regarding Harvard as well as UNC and their admissions practices. And she was quoted even above Professor, now Dean Erwin Chemerinsky. So I would recommend that everyone read her Law 360 article. But with respect to the legacy admissions, there are a few cases where courts have actually considered legacy admissions, one where the court directly considered it, and it was actually with respect to the University of North Carolina. And the University of North Carolina in the 1970s had a policy about 85% of their admittees were from the state, and the justification for 85% for in-state admissions was that most of those parents and families had contributed to the UNC system through taxes, and 15% were for out-of-state students. And the only exception was legacy students. So if you were an out-of-state student, but a legacy student, you didn't have to fall within that 15% quota. And because the quotas had nothing to do with race or sex, the court simply used a rational basis test and determined that schools can have legacy admissions because the rational basis was that the legacy students and their parents had contributed financially to the school over the years. And so this seems like it passes the rational basis test, and courts thus far have not found legacy admissions to be unlawful. So if I was in your shoes and the Board of Trustees or the Board of Visitors had asked me about liability with respect to legacy admissions, I think that the risk at this point is low that a court would find legacy admissions to be unlawful. However, there also is the Office for Civil Rights, and the Office for Civil Rights at the Department of Education enforces Title VI, which, as you all know, prohibits discrimination on the basis of race, national origin, and color. And even though you can't sue for a disparate impact claim under Title VI, the Department of Education's regulations with respect to Title VI do recognize a disparate impact claim. And so I think there could be an argument, and you might be seeing complaints from the Office for Civil Rights, if you haven't already, challenging legacy admissions, because really what that is a neutral policy that if your parent went to a particular college, then you also, as the applicant, would receive some kind of preference. And even though it's a neutral policy, it may have a disparate impact based on race. And the argument would go something like this. So if your school prohibited, for example, African Americans from attending or applying during one point in their history, then the applicants that are African American potentially would be less likely to qualify for the legacy preference, and that could cause a disparate impact based on race. And this Department of Education, the Office for Civil Rights, has signaled that it will continue to recognize disparate impact claims under their Title VI regulations. You might recall that in 2018, the Department of Education actually rescinded the Rethink School Discipline guidance and signaled that Title VI disparate impact claims would no longer be recognized. And the rationale was that in Alexander versus Sandoval, the Supreme Court of the United States stated kind of in dicta that if Title VI doesn't allow for a private cause of action under a disparate impact theory, then that statute wouldn't give the authority for disparate impact claims under the regulations. This Department of Education has signaled that it is rethinking that rationale and has also relied on other Supreme Court cases like Guardians Association versus Civil Service Commission to demonstrate that Title VI regulations may continue to recognize a disparate impact theory. So if you are looking at your admissions policy and considering what to do with legacy admissions, certainly if your state law prohibits legacy admissions, that's one thing. But I also would be mindful if your school has prohibited people from certain races or national origins from applying in the past, just looking to see whether the legacy admissions policies may have a disparate impact and just being aware of the issue. The other thing that you're going to continue to see from the Office for Civil Rights is that they have continued to take a kind of a heightened interest in claims under Title VI based on perceived ethnicity with respect to religion. And so again, Title VI does not concern religion or religious discrimination. There are other federal laws that other federal agencies enforce regarding religious discrimination. But the U.S. Department of Education's Office for Civil Rights has issued guidance that if you're being discriminated against based on race, but really through your religion, then that still is covered under Title VI. So just last month, the Office for Civil Rights opened an investigation into a complaint by Jewish students at Brooklyn College. And this was really kind of unique because the students were alleging that they were Jewish and they were being accused of white privilege and this kind of things that were associated with allegedly being white, even though they weren't white. They were Hispanic Jewish students. And so because of their Judaism, they were being perceived as white, and there were some other stereotypes that were kind of being pushed on them through allegedly professors and other students. And so the department's Office for Civil Rights decided to open an investigation into this complaint. And it's really interesting because the complaint, which anyone can access online because the students had posted it online, was actually filed over a year ago. And there's been a lot of changes with the Office for Civil Rights, but what's unique is that the Office for Civil Rights has kept its guidance in place regarding an executive order on combating anti-Semitism, and it's continuing to pursue claims under Title VI for students who allege that they've been discriminated against, really based on their race, but through their religion. So another example of this is with Muslim students, and the guidance that the department issued states that if, for example, a Muslim student that's wearing a hijab or that's wearing maybe a burqa is called a terrorist, then that would be discrimination that Title VI covers because religion is really being used as a proxy for race. So I think that if your Title VI policies, I think a lot of schools have looked at Title VI, especially with kind of recent events, and looking at your Title VI policies to see how they address religion with respect to race, that's important because I think you'll be seeing more complaints with respect to Jewish students as well as Muslim students. And again, with Title VI differs from Title IX currently in the way the Office for Civil Rights is enforcing it. So just as a brief reminder, Title VI, currently the department looks at whether the alleged conduct is severe, pervasive, or persistent. And so that's different from Title IX, which concerns sex discrimination. So the sex discrimination regulations state that the behavior or the conduct has to be severe, pervasive, and objectively offensive. But with respect to discrimination based on race, national origin, or color, it just has to be severe or pervasive. And the Office for Civil Rights still considers the responsible employee rubric. And so some of you might recognize that from the way that the department has previously administered Title IX. And really, it's a actual notice as well as a constructive notice standard. So if your professor knew or should have known that a student was being discriminated against based on their race and by proxy their religion, then that is something that the school would be responsible for responding to. And again, I think this is kind of unique because with Title VI, the school's response has to be an attempt to actually prevent the recurrence of that behavior. So it's not enough to just end the discrimination under the Title VI regulations. The Office for Civil Rights takes the position that the school has to respond in a manner that's reasonably calculated to prevent recurrence. So that might mean holding training sessions about Jewish students or Muslim students and kind of their cultural norms. And so these are things that schools may be thinking about. So if you kind of receive a complaint or these are kind of things that are brought to your attention, there are things that you can do proactively to help prevent the recurrence of any alleged behavior that could be discriminatory under Title VI. And of course, everyone's curious about Title IX and what the Department of Education will do with respect to the Title IX regulations. And I think we got a glimpse of what this Department of Education will do in its Notice of Proposed Rulemaking, which is forthcoming. The Assistant Secretary for Civil Rights announced that the Notice of Proposed Rulemaking will likely be issued in April of 2022. And I really had no idea why it takes so long for regulations to be issued until I worked at the Department of Education. And really the process is the regulations are currently with the Office of Information and Regulatory Affairs, and OIRA, that office, sends the regulations to every other federal agency that could possibly enforce Title IX, and all those agencies comment on it, and their comments are sent back to the Department of Education, and the Department of Education has to satisfactorily respond to all of these other agencies' comments. And in the meantime, the Office of Information and Regulatory Affairs has to hold what are called meetings under Executive Order 12866, and anyone from the public can request a meeting. They're held virtually. It's only 30 minutes, and it's supposed to really concern the regulatory impact analysis, but groups sign up all the time for these meetings just to tell the department what the regulations should or should not include. So if you would like, you are more than welcome to sign up for those meetings or have your surrogate sign up for those meetings because they're currently being held now. But the department has signaled really two changes kind of with respect to the 2020 Title IX regulations that were issued. They're going to revise the sexual harassment and sexual violence provisions in those regulations. And that's really all that the 2020 Title IX regulations did, was for the first time define what sexual harassment meant in regulations and how to respond to sexual harassment. But the second thing that's more interesting that the Assistant Secretary for Civil Rights has stated is that she's going to, and the department is going to, prevent and combat discrimination based on gender identity and sexual orientation through regulations, which would be a sea change because it would affect not just the sexual harassment and sex discrimination regulations, but it would really affect how all of the Title IX provisions, including on athletics and housing, are administered. And the department last year in June issued a notice of interpretation regarding Bostock versus Clayton County. And you might recall that Bostock was an opinion by the Supreme Court of the United States that concerned Title VI discrimination in employment. And Bostock essentially stated that discrimination on the basis of sex also includes discrimination on the basis of sexual orientation as well as gender identity. So the department currently is interpreting sex to include gender identity and sexual orientation and is taking kind of that position in enforcement actions. And there's a lawsuit pending in Tennessee by 20 states against that notice of interpretation, really alleging that the department should have gone through notice and comment rulemaking to make that kind of a change. And so I think that's what you might see in these regulations. So if I was in-house counsel, I would be surveying all of our policies and looking at whether policies that address sex also address sexual orientation and discrimination. And if you're a faith-based institution, I see some of the faith-based institutions have joined us. If you're going to claim a exemption, a religious exemption, I will note that that notice of interpretation had a footnote that the department would still recognize religious exemptions, but it's really up to you to make sure that your house is in order to demonstrate that you qualify for a religious exemption and that you're not treating people differently just because they are of a certain sexual orientation. So if you have a rule, for example, that all premarital sex is prohibited, that kind of conduct is enforced evenly irrespective of sexual orientation or gender identity. So what to expect? I think that the department gave us a few hints through its July 2021 Q&A on what to expect in any kind of forthcoming Title IX regulations. And I think one of the easiest targets is the definition of sexual harassment. So the 2020 Title IX regulations define sexual harassment in part as conduct that is severe, pervasive, and objectively offensive. But the department also took the position that schools could address conduct that is severe or pervasive through their other conduct codes. And the July guidance basically picks up on this and encourages schools to address conduct that is severe or pervasive. And so most schools actually have two policies. They'll have a Title IX policy that addresses severe, pervasive, and objectively offensive conduct. And then they have a policy that addresses conduct that is broader than that. And so I think that if this goes through and the department changes the definition of sexual harassment, what you'll see is basically people relying on the policy that addresses a broader swath of conduct. Another thing that you might see is that the department previously, before the regulations, through guidance documents and in enforcement actions, really required a preponderance of the evidence standard for their sexual misconduct proceedings within the school. And I think that that's another thing that you could see change. And so I think if there are a few schools who adopted the clear and convincing evidence standard when the regulations came out. And I think if you have, I think I would just kind of look through and see whether that's something that your school would like to maintain. Right now, the regulations state that you can use either a preponderance of the evidence standard or the clear and convincing evidence standard, but whatever you use for students, you have to also use for complaints with respect to students against employees, because what the department was seeing is that for complaints against employees, the higher clear and convincing evidence standard was being used, and so they were trying to level the playing field. With respect to a timeline for determining when a internal Title IX proceeding should conclude, you saw the department in its July 2021 Q&A suggest that nothing prevents a school from adopting a 60-day timeline, which is really a throwback to the 2014 Q&A that the department had issued. And currently the regulations state that a school may adopt a reasonable time frame. And I would just kind of look to what the department is going to indicate as a reasonable time frame in the proposed regulations and be prepared to kind of respond accordingly. With respect to cross-examination, just briefly, we saw this past summer that the Federal District Court in Massachusetts struck down a provision of the Title IX regulations requiring that a decision maker not rely on any statement that was not subject to cross-examination. And the Department of Education's Office for Civil Rights in August issued a statement saying that it would no longer enforce the provision that a statement has to be subject to cross-examination before a decision maker considers that. So that's still valid. I think what you're going to have to wait to see is whether the department will still allow some form of cross-examination through the parties' advisors, because there were quite a few comments the last go-around about not allowing cross-examination through parties' advisors. And if you're in the Third Circuit or the Sixth Circuit, where courts have basically through case law mandated cross-examination either directly between the parties or through advisors, that might be something you need to look at as to how to address going forward. Finally, the department used to take the position that a school was responsible for eliminating, preventing, and addressing sexual harassment. And that was the standard. It was almost kind of like a strict liability standard. So it was, you had to prevent sexual harassment from occurring again. And the department in its regulations currently uses a deliberate indifference standard, which is the standard for private causes of action under Title IX. And I think you might see the standard change again through this notice of proposed rulemaking. And that's something that I would really keep my eye out on. With respect to Title IX litigation, I would just mention that courts are still grappling with whether the school actually has substantial control over the harasser and the context in which the harassment occurred. And you really see this in two contexts. You see this when the alleged harassment occurs off campus, or the alleged harassment occurs by a third party on campus. And as courts are kind of grappling with this, you see kind of the Ninth Circuit decide that a football player that lives off campus but is using school funds to pay for that off-campus housing, the Ninth Circuit found that the school did not have to respond to sexual or harassment that allegedly occurred at this off-campus location. It was actually an assault. And that's because the court found that although the school had control over the harasser and could discipline the harasser, what the school couldn't do is really have control over the context in which that harassment occurred, which was off-campus housing that the football player chose to pay for, even though the school allowed that particular individual to live off campus. So I think that Title IX offices should really document whether they're going to address behavior that occurs on campus or off campus, and document why the school has control over the harasser and the context in which the harassment occurred. And I think that usually when conduct happens on campus, schools are almost always responsible, almost always, I say, because what happens is with third parties, there's a little bit of a question mark. So we recently saw in January, the Third Circuit kind of address this with respect to third parties, and a third party not affiliated with the university spent the night with the girlfriend who was a student at Millersville University, and he eventually murdered her, but there was a lot that had happened in between. But the court essentially looked to two things. They looked to that school's Title IX policy, which stated that it applied to third parties. And the court also looked to the fact that the school had a policy on guests and whether guests could stay overnight, and basically previously forbade this third party from spending time in that dorm room. And so because the school had control over the third party who was staying in a dorm room that the school maintained, and the Title IX policy stated that the school had control over third parties, here the court found that the school could have liability with respect to third parties. So I think that if I was a Title IX office, with respect to formal complaints that are issued regarding off-campus conduct or conduct by third parties, I would really document the factors that you're using to determine whether you actually have control over that harasser. Can you discipline that harasser? Can you issue a no trespass order against that harasser? And do you have control over the context in which the harassment occurred? So even if the school is throwing an event off campus, can that school prohibit certain people from going to that event if they're acting out or if they're misbehaving? So these are all factors to document in your Title IX processes. And lastly, I'll just mention that I personally have seen an uptick, both while I was at the Department of Education and in private practice, on complaints regarding sex-based programs and non-athletic scholarships with the Office for Civil Rights. And I think that most schools that have sex-based programs or that offer sex-based scholarships have the best of intentions. You're trying to offer opportunities to people who may not have had those opportunities in the past, but the department really does kind of take a strict position in enforcing these regulations. And there's really kind of two ways that you could have these sex-based programs or sex-based scholarships and justify them. So really you can show that there's an affirmative action reason for having the sex-based program or the sex-based scholarship. And by that, I mean you could demonstrate that, for example, women didn't have very many opportunities in the STEM field, or women weren't admitted at your institution until the 70s, or whatever the reason may be, and that these sex-based programs are necessary to overcome kind of the past effects of these policies. And that's really both for sex-based programs as well as sex-based scholarships. But another thing you can do with respect to the sex-based scholarships is say you have a pool of scholarships and everyone's going to be granted a scholarship for approximately the same amount, irrespective of sex. So even though you accept a sex-based scholarship, that doesn't mean anyone would be denied a scholarship because of sex. So everyone who applies will get a scholarship. It just happens that some of these scholarships, the donors wanted it to be for a specific sex. But at the end of the day, there's no sex discrimination because anyone will be awarded that scholarship. And if you kind of have these are reasons that you can set forth for the Office for Civil Rights. And again, just real briefly, as a reminder, with the case processing manual, if you're going through some kind of complaint or investigation with the Office for Civil Rights, there are ways to get out of it and kind of speed up the process with the Office for Civil Rights. So if your sex-based program appears to be sex-based, but in the recent past you've allowed anyone to attend, irrespective of sex, then I think that one way to resolve it is through a Section 108K resolution, where you just demonstrate that people of all sexes are permitted to be part of that program. And there's always, if you have a specific complainant who was a student or who was denied an opportunity, ask the Office for Civil Rights for a facilitated resolution, which is essentially a mediation that the Office for Civil Rights will help conduct. And finally, if you know, okay, this sex-based program is truly a sex-based program and there's no justification for it, I think the Office for Civil Rights appreciates a proactive approach and you approaching them about a resolution during the investigation, which will not result in a letter of findings against your institution, but will result in a resolution letter. And with that, I'm actually going to turn it over to Sarah to talk about the new OFCCP directive.
Oh, sure. Okay, so last week on Pay Equity Day, the OFCCP announced a new directive that applies to federal contractors and pertains to pay equity audits. And the news release, interestingly, refers to a requirement that you do an annual in-depth analysis of your pay compensation practices. And so to me, I was aware that federal contractors were supposed to be doing pay equity audits, but this idea of doing it annually seemed a little bit new to me. So the directive clarifies that the OFCCP expects federal contractors to affirmatively use pay equity audits to address disparities in gender, race, and ethnicity-based compensation. So I think that it's really important for your institutions to be doing these pay audits regularly. I'm not aware of many institutions, if any, that do them annually. And I think you need to think really carefully about how you're setting that audit up, how you're setting your affirmative action plans up. Are you doing one for the university, or are you breaking it out by college or school? In my opinion, it's probably a best practice to do it by college or school. And the key thing to kind of think of when it comes to these pay equity audits is OFCCP has made it really clear that if you're doing a pay equity audit to satisfy your affirmative action compliance obligations, you can't withhold that audit on the basis of privilege. You can conduct separate privileged pay equity audits, but you cannot say, we're not going to give you our pay equity audit to demonstrate affirmative action compliance because we did it under privilege. So I would encourage you to read the new directive, to reach out with any questions that you have, and to really engage with your team that's responsible for making your AAPs every year, whether that's human resources or your kind of Office of Equity equivalent. So we're going to shift a little bit now, and in about like 10 minutes or less, talk about one of the most complicated topics that's out there these days in the world of college, which is what I'm calling the alphabet soup of college athletics. A little bit of a funny story. I initially called this, the alphabet soup of college athletics, the real March Madness. And then I was told that March Madness is a trademark term and I couldn't use it. So I'm not using the term March Madness, so I will just say it's year-long madness that stems from this alphabet soup. And by alphabet soup, I mean A for Alston, NIL, NLRB, the FLSA, and the NCAA. So just to kind of quickly go through these, you all know that post-Alston, the NCAA rules now allow schools to give education-related benefits, which can include tutoring, expenses related to studying abroad, computers, post-eligibility internships, science equipment. You can give now, schools can now give those education-related benefits, which is a very broad and very undefined term, to their student athletes. And they can also give them up to $5,980 a year in academic achievement awards. We are seeing that $5,980 academic achievement award really grow in popularity. If you are a school thinking about giving your student athletes that $5,980 A for Alston award, I would encourage you to not just give it to your football and basketball players. I would think really hard about potential Title IX impacts, and I would think about giving them to all of your student athletes, which most of the schools who are giving this award are doing. And I would also think proactively on the front end about how this award could impact financial aid. I've seen a couple schools do some really clever things to try to make sure that this money doesn't impact their students' financial aid awards, including saying that they can get the $5,980. Essentially, they're putting it in trust for the student athletes when they graduate. So think very carefully about how awarding that money could impact your student athletes and who you're giving it to. The other kind of big thing that's happening right now is this name, image, and likeness space. So the NCAA, some of you might not know this, is requiring all schools in Division 1, 2, and 3 to have an NIL policy in place by the time the new constitution goes into effect, which is August of 2022. So if you are a D1, 2, or 3 school and you do not have an NIL policy, you need to start drafting one. And if you have a state law, you of course want your policy to mirror that state law. If you do not have a state law, you want to make sure that your policy is following the NCAA's guidance on name, image, and likeness, which includes a prohibition of anything that resembles pay for play. So there are a patchwork of state laws in place at the moment. In my opinion, those state laws were passed in part to put some pressure on the NCAA. States are now talking about repealing their legislation. Alabama was the first state to do that, which I think they repealed their NIL legislation in February 2022, so something to be aware of. I think it's very unlikely that there will be federal NIL legislation, but it's possible, I suppose. One thing to keep your eye on, the NCAA enforcement staff, which is the entity responsible for investigating potential rules violations of the NCAA bylaws, has indicated that they are looking into some NIL deals. They are not enforcing their interim NIL policy, and they are not looking at the deals with particularity. What they're doing is seeing if any of the existing NIL arrangements that schools have facilitated with student athletes run afoul of any of their existing bylaws. I think probably most likely they're looking to see if any of the NIL deals run afoul of pay to play. And so we'll see what the enforcement staff does with that, but I know that they are looking into this with increasing concern. And frankly, I don't blame them. Some of the NIL deals that I've seen come out in recent months look a lot like pay to play. So I would, as the legal office, make sure that you understand the NCAA's compliance regulations and make sure that you understand what is your athletics department doing? How involved are they in these NIL deals? What type of review are they providing to NIL agreements? And what type of training and support are they providing to student athletes? I think it's really important that you tune into these issues within your department. The other thing that I would keep my eye on if I were you in the NIL space is which is called the House suit. So there's a lawsuit. It's another antitrust lawsuit So that's at least 3 big ones that are kind of on the main stage right now in the world of collegiate athletics and colleges and universities in general. I would keep my eye on this House case, which is pending in the same court in the Northern District of California that decided the Alston case. And the House case alleges that the NCAA, as well as the Power 5 conferences, violated the antitrust laws essentially by prohibiting student athletes from earning compensation for their name, image, and likeness up until about July 1st of 2021. The interesting thing is that the case is also alleging that football and basketball players are owed a share in the telecast licensing revenues that schools and conferences can often get from, by virtue of their participation in a conference. And the case actually survived a motion to dismiss, and it's set for trial, I think, in January of 2024. But I would certainly keep my eye on this because, if damages are awarded in that case, backward looking for student athletes who weren't allowed to profit from their name, image, and likeness up until June 1st of 2021, the potential damages there could be really, really significant, and I would have my eye on it. Okay, moving along in the alphabet soup, the NLRB. So many of you know, in September 2021, the general counsel of the NLRB issued this memo saying that football players and similarly situated players at private schools are employees under the National Labor Relations Act. So as employees, I should clarify, it's her position that they are employees under the National Labor Relations Act. Her memo does not have the force of law. It does not mean that these student athletes were automatically converted into employees. It was her statement that that's her office's position on these student athletes under the National Labor Relations Act. And as such, because she believes that the student athletes are employees for NLRA purposes, she believes that they then have the right to unionize, protest, and strike. The most fascinating thing about her memo to me was a footnote that kind of slid in under the radar on the last page of the memo that said it might be appropriate for the National Labor Relations Board to assert jurisdiction over the NCAA and the conferences, and possibly to find joint employer status with public institutions. So typically the NLRA only applies to private sector employees, and state and local government entities, the public schools, are typically exempt from the NLRA's jurisdiction. But I think the footnote is challenging that premise a bit. And we saw the first unfair labor practice charge since the memo came out come in February 2022 against the NCAA, so the governing body, the Pac-12, a conference, UCLA, a public institution, and USC, a private institution. So this case is really, I think, by design, going to test that footnote and going to test the potential jurisdiction that the National Labor Relations Board has over the governing body, the conference, and then a public school. They certainly have jurisdiction over the private school. So the ULP alleges that the schools and the organizations violated the NLRA by misclassifying these student athletes. And this one, again, focuses on football and basketball players. And what's now going to happen is the regional office in LA will investigate the charge, and they could then issue a complaint, which seems likely to me, given the memo. So I think it's probably very likely that the regional office will issue some type of complaint to at least some of the entities involved in this unfair labor practice charge, and it will then work its way through the National Labor Relations Board and possibly the courts, including the Supreme Court. There could be more student athletes, or groups that file unfair labor practice charges. So just because this one was filed in the LA region doesn't mean that student athletes at your school or at other institutions can't follow suit. So what would I do? I really recommend engaging with your athletics folks about this. You want to think about the education-related benefits. What are we providing under Alston, and how are we providing it? I haven't seen a ton of schools do anything like the internships or the computers, but like I said, there is an increased movement to provide the $5,980. So how is your athletic staff thinking about this? What are they doing, and how are they doing it? And in terms of the NIL space, how are you engaging with student athletes on NIL? Do you have folks from your business school coming over to teach student athletes about how to market and brand themselves? Are you offering those opportunities to all of your student athletes equally? You know, what is your process? When do you insert yourself? Are you reviewing all of the NIL agreements, or are you only reviewing those over a certain dollar threshold? There are some state laws that speak to this issue, but others don't. The other thing that I would think really hard about when it comes to this issue of student-athlete unionization is thinking about how is your athletics department engaging with your student-athletes. So do you have a student advisory board that has a direct line to your athletic director and other senior officials in your administration that can share kind of the pulse of what's going on with student-athletes and share their concerns? Do you have an anonymous complaint mechanism where student-athletes can raise concern about coaches or staff or other issues they're seeing on their team? Do you have a point person in your athletics department who students know they can go to about diversity, equity, and inclusion? And I think, you know, it's really all of these things, right? The Alston lawsuit, the NIL lawsuits, and the laws that are happening right now, and this issue of student-athlete unionization, they're all happening because student-athletes feel like they haven't been treated the way that they should be treated for a certain number of years. It aligns in a lot of ways with other social justice movements that we're seeing. And I think one great way to manage that is to make sure that you're engaging proactively with your students. Similarly, I think you as the legal offices want to make sure that your athletic staff know what they can and can't do when it comes to talking about unionization issues with your student athletes. So there are very particular frameworks that apply in terms of what you can and can't say about union activities. And I think you want to make sure that your head football coach isn't going to the student athletes saying something like, you better not unionize or you're off the team. Sounds crazy, but it has happened. Kind of flying through this quickly. So the Fair Labor Standards Act, this is the one that I would watch. I would watch this maybe more closely than even the NLRB issues. So we know the Fair Labor Standards Act applies to both public and private schools. In this suit, Division I student athletes allege that they are employees of their member institutions by virtue of the fact that they participated in intercollegiate athletics. The Seventh Circuit and the Ninth Circuit have previously said, no, student athletes are not employees for purposes of the Fair Labor Standards Act. And this district court in Pennsylvania denied the motion to dismiss filed by the schools in the NCAA. And the district court said, I think it's plausible that these student athletes could have properly alleged that they're employees under the FLSA. The Third Circuit granted an interlocutory appeal on this exact issue, and the case in the lower court is stayed pending the Third Circuit's opinion on whether or not these student athletes can be considered employees for purposes of the FLSA by virtue of their participation in their sports. I checked the docket this morning in the Third Circuit. So far, only appearances have been filed, but let's keep an eye on it. We'll keep kind of touching on this in future sessions and see where the Third Circuit heads on this, because this to me is an interesting one. So last but not least, the NCAA. A new constitution goes into effect in August 2022. It was the product of a very lengthy set of work by a group of members who really worked hard to kind of think about how to reshape college athletics. There's a shift in this constitution from what they used to call the principle of amateurism, which got absolutely roasted, by Justice Kavanaugh in the Alston opinion, and they're now calling it the collegiate student athlete model. And there's still this principle that you can't be paid by your schools to participate, but you can receive educational and other benefits in accordance with guidelines established by the division. Again, as I mentioned before, you have to have an NIL policy if you're in D1, D2, and D3. And the last thing I really want to highlight for you, which I also think is something flying under the radar, is that the Board of Governance has a new policy on campus sexual violence. Every year for the last 3 or 4 years, your president or chancellor, athletic director, and Title IX coordinator have had to sign an attestation by May 15th. So this year's attestation is coming up. It's almost due, where they attest to the fact that everyone in the department has received training, that they know how to find the Title IX coordinator. But coming in the 2022-23 academic year, those attestations need to have new, really complicated provisions in them that I think schools need to be well along the path of developing by now. So specifically, incoming and transfer and continuing student athletes have to complete this annual disclosure related to their conduct that resulted in discipline through a Title IX process or in a criminal conviction for sexual, interpersonal, or other acts of violence. Transfers also have to disclose if they left or want to leave their school in the middle of a Title IX process. And to me, the kind of wildest thing or most complicated thing about this, if you're an in-house attorney, is that institutions have to take reasonable steps to verify the information, which the NCAA says can include contacting high schools for your incoming student athletes and the colleges and universities. So you also need to have a written policy that dictates how you're doing this. So if I'm in your shoes in the very immediate future, I would talk to your Title IX coordinator, talk to your athletics department, and see what their plans are for doing this. I would make sure that you're looped in on the written policy and on the disclosure forms, because obviously there are a host of privacy issues that come into play here, including FERPA. I think you need to loop in your admissions folks to make sure that they're aware of this. And if I were you, I think that you should be ready to answer the question of why you're doing this for your student athletes with Title IX issues, but you're not doing it for the rest of your student body, and you're not doing it for example, other forms of discrimination or harassment. Whew, so that was probably the fastest I've ever talked, and I'm Italian, so that's really saying something. We only have about 3 minutes left. I've seen one question come in, which is whether or not you will get the slides. Yes, we will send you the slides along with the recording. So assuming there are no other questions, there's one other thing that we wanted to flag for you all in the final minutes of this presentation, which is something that I'm getting a lot of phone calls about, and we're seeing some lawsuits start to trickle in. And that's work from home accommodations after we're kind of all returning to campus after COVID. So a lot of people are having their students, faculty, and staff come back to campus. There are people now saying, I want to work from home as a reasonable accommodation. The good news is that the EEOC says that, look, just because you work from home during COVID, it doesn't mean that in-person attendance is now not an essential function of your position. But here's what you need to make sure you're doing. Contact HR, contact your folks who oversee discrimination and harassment entities, whether that's the Office of Equity or your Student Disability Services, and make sure they understand that they still need to be engaging in the interactive process to determine the essential functions of a role and if there's a reasonable accommodation available. And what I'm seeing happen all over the place is supervisors, professors, deans are saying, look, in-person collaboration is an essential function of this position, and so I need my people to come back. And is that enough to show that that's an essential function of the position? No, it's not. So you need to think about how other employees function. You need to think about how much time is spent on in-office tasks. You need to think about what your job description says. And I see a lot of people shortcutting this and just relying on the in-person collaboration justification. And I think that that's really fraught with issues. So I would reach out to your folks doing accommodations. A lot of them are really stretched thin right now. They have a high volume of cases, but just make sure to reemphasize to them the importance of the interactive process and really doing a thorough analysis on requests that come into you. So I've now completely run us out of time. If you have questions, please follow up with us anytime. We're again so grateful for your time today, and we hope to do this again very, very soon. So thank you all so much for coming.
Thank you. Bye-bye.